This is an appeal in the matter of the Mayor and Commonalty and citizen of the City of London and 48 Street Holdings Ltd and another.
Yes, Mr. Collins.
No, please, my lords and my lady. I'll pick up from where I left off yesterday. So just to reorientate the court, I was dealing with the statutory scheme. I'd shown the court section 43 and section 45 from the primary legislation. I was going to go to the delegated legislation, the 2008 regulations, which, if the court could pick those up, please, at page 30 of the authority bundle. And the court's already seen regulation 3, which is the hereditaments prescribed for the purpose of section 45(1)(d), and that's the class of non-domestic hereditaments prescribed consists of all relevant non-domestic hereditaments other than those described in regulation 4. And my learned friend Mr. Forsbeck, as a shorthand, said it's everything. That's not quite right for two reasons. One, we touched on yesterday, which was the approach to industrial, but secondly, there is a qualifier. If you go back to regulation 2, there is a definition of relevant non-domestic hereditaments, and that means any non-domestic hereditament consisting of or of part of any building. So it's not all hereditaments.
Okay. Sorry, just on the industrial point,
Yes.
that's not carved out of 3, it's dealt with in 4B, isn't it?
My lady's quite right. My lady's quite right about that. That's right. It's a carve out from the general rule.
So, but Reg 2 basically covers everything if it's a building,
Or consists of a
together with
building. Yes.
related land.
Yeah. Well, yes, but there are. I think it is worth understanding. Not an issue in this case, but there might well be valuable hereditaments. For example, a mine consisting of the use of land plus plants without a building. There might be issues, for example, in relation to cement work. So I'm just simply trying to put that thought that one needs to read the inclusive prescription against the context that it has to be a relevant hereditament in regulation 2. This case plainly doesn't turn on.
Just before you leave Reg 2,
Yeah.
relevant non-domestic hereditament. From memory, that's a term of art also defined in the primary legislation.
Can I?
But assuming it is,
Yes.
the draftsman has specifically defined the term for the purpose of these regulations.
That's correct.
I mean, the interpretation section of the 88 Act defines hereditament, non-domestic, and also relevant, what is relevant land.
Right.
So, and those 3 terms are joined together. But I've never seen this before, so this is a specific definition here.
Well, perhaps junior counsel could check this. Let's hope the definitions are.
Can we come back on that, because my learned friend my learned junior indicated there might be some differences. So can we check that and come
It does
back?
not matter. But
Yeah, and it doesn't turn on that, but it does. It may be relevant to just understanding the shape of this and
why
whether.
have they done this here?
Yes, and for the time being, because of course my primary submission is all of this is, if you like, within the choice, the broad choice given.
I mean, this is focusing. One obvious point is it's focusing on buildings.
Yes. So that's all I was going to for the
Yeah.
purpose of that. Can I then go more to the heart of the matter, which is regulation 5? You'll find that on page 31.
Yeah.
I'm going to use this, but please note that this is as amended by the 2004. So where it says 13 weeks, it should say 6 weeks for the applicable regulation. But I want to pick up, if I may, on observations.
Sorry, 6 months.
6 weeks. This is the reset period. Did I say 6 months? 6 weeks, my lord. In the
reset period.
the reset, the qualifying occupation.
Oh, sorry.
Needs to be for 6 weeks. Yes, my lord's right. There is a 6 month. That's in.
That's the exemption.
That's the non-prescription for qualified industrial. But it's 6 weeks that changed to 13 weeks.
Yeah.
Now, central point that I make is that creates the period by reference to the concept of occupation, and as we've discussed already, it's common ground, at least as I understand the perspectives being put to you from the bar, that means the same thing as section 65(2), and my submission is that's a choice and it's within the Secretary of State's gift to do that. But there was a helpful observation by my Lord Justice Holgate, if I may say so, an observation that in part this is a deeming provision, and I respectfully agree with that, but it is important to be precise as to the way in which it does deem. The deeming goes to the length of the period, not the quality of the occupation. So it only, and may I just explain that, because it's not self-evident how that works, it only deems as continuously unoccupied for the purpose of regulation 4A if the period of putative occupation has been 6 weeks or less. So if you imagine a 5-week...
Sorry, less than 6 weeks.
Sorry, forgive me. Thank you. Less than 6 weeks.
I don't think yes, you need to unpack your submission again.
Yes, well, I hope I help with this illustration. So if we imagine a 5-week period of uncontentious occupation, and if I can adopt my lady's example of a pop-up shop, so we're not in rates mitigation territory, we're just in a short-term occupation, and let's assume there's no transient issue in relation to that for the purpose of this, and I would submit that there might not be. So during each day of that 5-week period, the pop-up shop is an occupied hereditament for the purpose of section 43. And therefore, it is not an unoccupied hereditament for the purpose of section 45, because the court will recall one of the conditions of section 45 is that none of the hereditament is occupied. They are, if you like, binary concepts. Once it stops being occupied and it moves back into the section 45 domain, because it's not occupied in fact, it is deemed to have been continuously unoccupied for the purpose of considering whether it's a prescribed hereditament or taken out of being a prescribed hereditament within 4A. So therefore the hereditament on the cessation of the occupation after 5 weeks is immediately a prescribed hereditament as soon as the 5-week occupation stops. So the deeming...
No, wait a minute. You left out before the 5 weeks.
Yes.
The place was empty.
It's occupied for 5 weeks, I think, is your factual example.
Yes, I'm not sure it matters. It does matter. You know, my lord's right. It does. My lord is absolutely right. It has to be a sandwich situation for this provision.
I suppose that the 5 weeks, whatever the 5 weeks from the 1st of January are to say 5th of February. So
yeah.
Before the 1st of January, it's unoccupied on any view. Then you have 5 weeks of a pop-up shop.
Yes.
Then the pop-up shop is closed
yes.
and nothing's happening.
Yes. And what I'm trying to do, and I hope it's helpful because it's not self-evident how this works, is to say that there is a deeming function, but the deeming function is very specific to the qualification under 4A. It's not a deeming function that relates to the quality of occupation in any way. It could be perceived and conceived differently, but that is not how it is done. The deeming relates to the effect of 4A and 4B in terms of the reset, and it goes to whether it is deemed to be being continuously unoccupied, but it's only where it falls short of the 6 weeks qualifying occupation that is a relevant deeming provision.
Are you saying, I'm still not sure I've understood your point fully, if you're simply saying that the deeming is for the purposes of Reg 4A, that's evident. don't think anyone would say anything else. That's evident from what Reg 5 says. So I think I might still be failing to capture.
Well, that is a key point. But the reason that I'm perhaps labouring it is that the language of deeming provision was identified by the court. I think it is helpful because it's very much part of my case that there could be a different form of deeming provision here going to the quality of the occupation, and there is not. But the boundary between occupied and unoccupied has been thought about in this way and is coherent within the scheme, because on any given day, any hereditament can only be occupied or unoccupied. It cannot be both. That's absolutely critical to the functioning of the scheme. So in this scenario, for that 5-week period, everybody agrees it's section 43 occupied, rates are due for every day of that 5 weeks, and it can't be an unoccupied hereditament on any of those days. But then you've got a clever and deliberately focused mechanism for making sure that it is immediately a prescribed prescribed hereditament, because what it does is it goes to the calculation of the period under 4.1a and 4.1b, and it becomes eligible for unoccupied rates for 2 reasons: the prescription, but also because none of it is occupied.
Can I have a go at this in a no doubt inept way? Because I didn't find this very easy. I approach Regulation 5 for the moment on the basis when it talks about occupation and non-occupation, it's, as you've said already, classic concepts, rating concepts, section 65, etc.
Yes.
And I'll just make 2 simple points. One, going back to 4A, you could have a situation where there's been a period of non-occupation for a continuous period which exceeds 3 months. And in that situation, you don't get the benefit of the exemption. The alternative is you've got a period of non-occupation for less than 3 months. What, as I understand it, 5 does in that situation, because there's only 2 possibilities as far as 4A is concerned. But if you then turn to Regulation 5, if you have a period of occupation, and you give an example of up to 5 weeks, I mean, during that period of up to 5 weeks, it's counted as occupation. You don't necessarily know how long that's going to go on for. When you get to the end of that period, you know that it was definitely less than 6 weeks. In that event, that period is added to the period of non-occupation which preceded it under Regulation 4, and you find out whether you go, by adding the 2 together, you find out whether you go beyond 3 months. Have I basically got it right?
My lord, yes. And it goes entirely to the statutory function of 45(1)(d), the prescription. But of course,
if you analyse it as a computational provision in that simple way,
yes,
I can get my head around.
Yes.
It's not saying anything. It's not altering the concept of occupation.
That's precisely my point. Where it takes me is another matter, but that's precisely my point.
Yes.
Yeah.
Sorry.
No. But so I hope that
I'm
helps.
very worried I wasn't understanding.
No, well, I made.
Okay, I will put another way. I think we understand. No one's saying that there's a different concept of occupation. I don't understand anyone saying there's a different concept of occupation.
No.
And your overarching submission is that the Secretary of State has chosen that concept.
Yes.
And it's a very broad, essentially, it's a very broad concept.
Yes. I mean, that's a key part of my case. It's yes. So I hope that was anyway. We've done that exercise. The short point is the deeming goes to the timeline, not to the question of occupation, and I also suggest tentatively that's to make sense of the binary division between occupied and unoccupied that pervades the whole statutory scheme. And I readily endorse the consensus that Reg 5, as currently drafted, and it's a choice for it to stay like that, takes the same concept as Section 65(2). Now, part of the reason I thought it might be helpful to think about this in terms of a deeming provision is the rate scheme does have some deeming provisions, but they are, if I can put it this way in very broad terms, the exception rather than the rule. The rule is you rate as things stand, and then there are certain elements within the scheme where there are statutory interventions to take it on a different basis. Now, one of them is actually quite close to this, which I'll show the court in a moment, but just if I can set the context to give a couple of examples of that. So, for example, on the question of when a building under construction comes into the rating list, there is a process called a completion notice, and a completion notice basically declares the building to be complete, and it can do that either because it is in fact, or it is deemed to be complete. So that's one example where deeming is used in the rating scheme to make things function effectively. Another example that's slightly closer to home is if I could ask the court to go to page 19 of the authorities bundle. Within section 65, there is a provision that is relevant to the demarcation between occupied and unoccupied property. It's not an issue in this case, but it is relevant to notice that it does a deeming function. So that's 65.5. A hereditament which is not in use shall be treated as unoccupied if, apart from this subsection, it would be treated as occupied by reason of having there being kept in or on the hereditament plant, machinery or equipment which was used in or on the hereditament when it was last in use, or which is intended for use in or on the hereditament. So you can have a situation where the mere fact that there is things left over, like furniture, etc., might, under the general law, be occupation. But here, for the purpose of allocating it as between the binary concepts of occupied and unoccupied, there is a specific and directed deeming provision. That is how the scheme functions. And that's not in play. That provision for interest was in play, although it was held not to help on the facts of Public Health England. There was some argument about that provision. But for present purposes, I just asked the court to notice this statutory provision has deeming provisions within it. Another one, which is again relevant for present purposes, is that when empty rates was reformed in 2007-2008, a provision was added to the statutory scheme in section 66A of the 1988 Act, which was an enabling provision to for the Secretary of State to create regulations disregarding physical changes. Now, we haven't got that provision, we can provide it to the court, but it is noted in the explanatory memorandum, which is at page 14 of the supplementary bundle. So there is a reference to the sort of the policy context of that, and I'm happy to turn that up if that would assist, or just leave that reference with the court. But just very, very briefly, if I this is from the explanatory notes to the 2007 Act. It's paragraph 8. The Act also makes consequential amendments to the legislation. This includes inserting into it a new section allowing the Secretary of State to make regulations to prevent changes in the state of property operating as a means of avoiding unoccupied property rates.
And that became 66A.
66A, and it's common ground, as I understand it, that no regulations have been made under that enabling power. So the point that I make is that absent special circumstances, the rating scheme is concerned with whether the property is in fact occupied or is in fact unoccupied, not, and I stress this, how it might or ought to be used or not used.
Can you just bear with me? I haven't looked at 65.5 before. So, say, floor of an office building was used as an office. It was occupied, and the business moves out that leaves behind desks and stuff. But nothing is happening at the property. So it's a hereditament which is not in use. It's treated as unoccupied because if the only thing to say it was occupied was that there was desks and chairs and so on, but the property is not in use, it's treated as unoccupied.
Yes.
But it's funny then that it's different if you move in boxes.
Well, the provision that this is dealing with is to avoid a particular kind of debate as to whether leaving the furniture in place is the assertion of occupation, but it's proceeding for the purpose of my submissions on the express understanding that that might otherwise be occupation, because it has no traction unless it would be treated as being occupied. So it's either otiose or there's a problem to resolve. Now,
Or it could be the avoidance of doubt.
well, it could be. No, I accept that. Although it would then not have any traction, would it? Because no, I suppose it might.
It's
It
for
might.
the
It's for the
traction is
avoidance.
avoiding doubt.
Yes, yeah. But the existence of that doubt is relevant where there is no provision for the avoidance of doubt. I submit. My lord, my straightforward answer to my lord's observation is it might well be thought odd, and that might mean the Secretary of State needs to actually be a bit more active in prescribing a similar type of provision under his wide power to do so for the purpose of how unoccupied rates works.
I think there is a doubt in this area because it's a long time since I've looked at them, but there are all sorts of cases going back to the 19th century where you've got a building which is unoccupied, but there are some artifacts in the building. This happened with cotton mills, for example, during the American Civil War. They were all empty, and you find my recollection is the decisions go either way over the years. They're not easy to reconcile. It ended up with Townley Mill,
Yes.
in the House of Lords in the 1930s, but this is a very difficult area of rating law.
And there's also if
So
it
you can
helps.
understand the Parliament saying, well,
Yeah.
we don't want
No,
judicial agonising, we'll just have a deeming provision.
no. Well, my lord, I adopt that, and I submit on the back of that precisely so. When there's doubt, make it clear. And it's not. I'm not saying there needs to be primary legislation. I'm saying the Secretary who understands all of this can very easily make it clear. And of course, the other provision that I ask the court to bear in mind, simply by noting its absence, is, and I won't take time on it, but in the authorities bundle between page 12 and 15, you'll see that there are provisions that are only effective in Wales, and they are the General Anti-Avoidance Scheme and 63 I on page 13 is effectively a deeming provision, effectively deeming occupation in circumstances where that is triggered. In other words, an artificial non-domestic rate avoidance arrangement as defined. So again, I'm not saying the absence of any provision in England is conclusive. The situation in England is the Secretary of State is actively considering whether to insert such a rule, consulting on it, hasn't done so yet. I take my lady's observation that in tax this is not an unusual situation, but I do submit nonetheless that in rating the absence of a deeming provision is of some interest.
On your approach, what you've been saying, that this is all within the Secretary of State's power, one wonders why primary legislation was used in Wales.
It's more.
That's a legitimate question.
Well,
query.
so let me answer it now. Let me show you the material. So the material. So I think it's generally accepted that a general anti-avoidance rule is more wide-ranging than prescribing conditions on occupation. That has been used through primary legislation in Wales under the delegated powers. It hasn't yet, but it's on the agenda in England. But when we look at when we look again at the 2014 regulation consultation, there were three things on the menu. There was increasing the reset period. That didn't require legislation, it was by regulation. There was limiting the number of times you could use it. Again, my submission is that wouldn't require legislation, that was by regulation. And there was adding conditions, and I'm going to say that is, i.e. changing the rules of occupation for the purpose of Regulation 5. And self-evidently, I submit, that didn't require primary legislation. That was an act that could have been done by secondary legislation. We'll see when we come to it. The reason it wasn't is that it was felt that it would actually diminish the coherence of the statutory scheme. That's what's said in the explanatory memorandum explaining why the only change that was brought in was increasing the reset. That's a rather important thought, I respectfully say, for the purpose of the Ramsay arguments.
Well, were the sections 63F and onwards, are they there by reason of an act of the Senate or of Westminster?
I'm so sorry, my lord, may I ask you?
Was 63F and so on, at page 12
Yes.
onwards, were they an act of the Senate or an act of Westminster?
Of the Welsh Assembly?
Yes.
Welsh Assembly, yes, yes. And so my submission and understanding is that in England a similar provision would need primary legislation. May I then just say a word about the statutory history? I discussed this. We discussed this yesterday, and just as a reference, some of the points on this are drawn together in paragraph 21 of our skeleton. But I do say that the City of London's case is built on the proposition that the scheme has been largely unchanged since 1966, and I say that that's not a fair characterisation of what's happened. The reality is it's been a patchwork of policy interventions which are capable of being traced back to 1966, but there are significant changes as to, as I said yesterday, the ambit of what is within prescribed hereditaments, who controls prescription, that changed in that period, and the rates of unoccupied, and the rates, the 100% to the increase from 50 to 100. But I positively accept that the reset period has remained unaltered, but the ability to alter it has vested in the Secretary of State since December 1989, when the 1988 Act came into force. But it's remained connected to the concept of occupation, importantly, as understood in the pre-existing law. So that's the dilemma. That's how it's crafted. The maintenance of that is within the choice of the Secretary of State. The important question, is the extent to which the introduction of, if you like, policy relating to unoccupied rates in itself alters the concept of rateable occupation. And my submission is the courts below have correctly proceeded on the basis that it doesn't. All it does is it brings about a reversal of the usual roles. People swap side in the debates, but they're applying precisely the same criteria. And you can't use, I would respectfully say, the role of that Regulation 5 to fundamentally alter the concept of rateable occupation. That's my submission. And I'd like to show the court an authority of the Supreme Court that I think does assist on this, albeit it's not directly in point. But may I take the court to tab 30, page 459 of the bundle of authorities. And this is the decision of the Supreme Court in Nuffield Health. And just to orientate the court on this, I'll explain what it's about in just a moment, but this is more than a year after Rossendale. It's after Rossendale. Let me just double check the timeline. Yeah, so it's it's effectively almost two years after Rossendale, and there are three members of the court that are common to Rossendale and this: Lord Briggs, Lord Kitchen, and Lord Leggett. Now, if I could just explain, we can go into this to the extent that it helps, but I'm not sure we need to, apart from one paragraph that I want to show the court. But the case is about mandatory charitable relief. It's an occupied property. It was Nuffield Health, and they were occupying what the council was saying was a commercial gym that was unaffordable and therefore failed the test of public benefit. And so the precise issue was whether you judge public benefit for the purpose of charitable relief by reference to the hereditament as an island, or by reference to the use the charity makes of the hereditament to deliver its overall purposes in the public benefit. And the Supreme Court adopted that latter formulation. They rejected the idea that there was a hereditament specific assessment of public benefit, and they did so adopting, unsurprisingly, a purposive construction that included, amongst other things, looking at a report called the Pritchard Report from the 50s, which led to the codification of mandatory charitable relief for the first time in what was then Section 11 of the Rating and Valuation Act 1961. But why I'm troubling the court with this, I accept that's a different context. It's occupied property, but it's about charitable relief. But the billing authority prayed in aid Rossendale. And if we go to page 477 of the bundle, it's paragraph 34. But let me just encapsulate the argument first and then show you what the Supreme Court made of it. So the billing authority sought to rely on Rossendale to say that the approach to wholly or mainly used for charitable purposes should be impacted by the fact that under the exceptions to unoccupied property, there was now a provision that when property was next in use, it was exempt from an occupied rate. So they were saying you should then look at that through the prism of Rossendale, and if you adopt the approach that Nuffield Health are arguing for, it will be a charter for avoidance because of the role that this plays in unoccupied rates. And the Supreme Court said that's just not in play, and the reason it's not in play is recorded in paragraph 34. Merton submitted that the statutory provisions relating to rates in respect of unoccupied hereditants provided guidance for the construction of Section 43. However, as counsel for Nuffield Health pointed out, these provisions dated back to 1966 at the earliest, after the enactment of Section 11 of the 1961 Act, and Section 45A of the Local Government Finance Act, on which Mr. Gowdy for the Billing Authority placed reliance, was only added after the 2007 Act. The chronology is set out in Rossendale. We agree with Nuffield Health's submission that these provisions have no bearing on the proper interpretation of Section 43.6, both because they post-date the enactment of its predecessor in the form of Section 11 of the 1961 Act, and do not support any inference that the meaning of the statutory language had changed, and because the policy context in relation to rates on unoccupied property as analysed in Rossendale is entirely different. Now, that's not directly on point, but it is, I'd respectfully say, of interest and potential relevance to the central thought that informs Mr. Forsdick's case on behalf of the City of London, that the meaning of occupation as it has been traditionally understood now needs to be rethought about through the prism of the role in unoccupied rates. My submission is that could be done, but it could be done by a change to the way that Regulation 5 is crafted. But if, as it appears to be, it's common ground that Regulation 5 is the same concept as is preserved by Section 64.2, in other words, the pre-existing law, then the policy debate has very limited traction because it's being utilised by reference to a concept that obviously predated. Everybody accepts it's being utilised by reference to the law as encapsulated in the Lang requirements. Well, the Lang requirements were formulated before unoccupied rates was a thing. Now, I appreciate my learned friend Mr. Forsdick relies on that to invite the court to go in a different direction to the one I'm inviting the court. But I say, if you look at that idea, that central idea, through the approach of the Supreme Court in paragraph 34 of Nuffield, it suggests that actually you can't use the policy impact of this on unoccupied rates to skew the concept of what rateable occupation is, when the statute obviously aligns the two as it does in Regulation 5. And as I keep saying, it doesn't need to, but it does. So that's
That is going to beg the question: what do we mean by occupation?
which it absolutely does. But
This was the thought which crossed my mind when you started that submission 10 minutes ago.
and I appreciate I have to engage with my Lord's observations in relation to that, and I will come to that very, very shortly. But I accept that begs that. But the reason that this is important.
So what we get from Nuffield is that. Sorry, can you just put it very simply for me?
Well, in that case, the concept of the purposive approach to mandatory charitable relief was not impacted by the subsequent adoption of that as a way of obtaining
Which I don't
relief
find very difficult.
for unoccupied. No,
So we don't get much help by looking at consultation documents related to 2024 either way.
not on this point, but my submission is you get a lot of help on other points, but I'll come to that. But that's not why I'm going to that. I'm going to that to say the role of occupation in Regulation 5 does not change the pre-existing approach. The pre-existing approach takes a particular broad and easy to catch approach to beneficial occupation. Whether it's good enough or not, I accept that's a separate debate. But in a sense, there's little for the Ramsay point to bite on here, because we agree that Parliament is adopting the same concept, and the Ramsay purpose in this particular exercise, if the words used clearly show they're using the same concept, then the consequences of that in unoccupied rates is nothing to the point. The question is, do we meet the statutory conditions, i.e. the established law of rateable occupation? I appreciate my Lord says we may not and wants to hear submissions on that, and I have to come to that. But my learned friend, as I understand the shape of my learned friend's case, his entire ground one is predicated on the proposition that the Lang requirements apply, but Ramsay adds something new. And my submissions here are addressing that point and saying emphatically they don't, because they take us back to the Lang requirements in terms, and this adds something to that.
That seems to be suggesting there's no scope for applying Ramsay, but maybe there is scope for applying Ramsay on the basis that the Lang criteria remain unchanged. But the issue is, how do you apply them to facts?
Well, yeah, and I will come to that. I will come to that, and I'm going to come back in literally just a moment. May I just put a marker down at the end of the statutory scheme section about the 2024 regs, which I will come back to. As I said, they changed the reset period. They don't make other changes, despite the far-reaching discussion. I need to obviously come to whether that assists the court and how, as I'll come to subsequently. But I'll go to the point that my Lord Justice Holgate is putting to me, which is the approach to rateable occupation. So my submissions on that are as follows. There's a century and a half of case law which applies the concept to capturing the essence of rateable occupation, and the established concept was developed in a world where there was no unoccupied rates. The legislative scheme clearly and unequivocally adopts this as the relevant test for Regulation 5, albeit that it doesn't have to. Our focus, as I understand it, is entirely on the concept of beneficial occupation. that in the case law is a low test. It is that there has to be some benefit to the occupier, some use or value or benefit to the putative occupier. That's how the point was put in submissions in Lang and was adopted by the court. Some use or value or benefit to the putative occupier. Now, we deal with this in detail in our skeleton argument. So I'm going to try to let that do some of the heavy lifting and take the court to the critical passages. So if I could ask the court to pick that up, please, at paragraph 40. So, forgive me, well, if 36 is where the heading beneficial occupation starts, that's on page 49 of the core bundle, please. And, we set out what we call 3 themes. And the first theme is there has to be actual occupation of the land and that is capable of generating a benefit from that occupation. We encapsulate that in paragraph 40 of the skeleton. And the basis of that is the Lambeth case is discussed there, which is the Brockwell Park case that you've seen, and in that case there wasn't beneficial occupation. I'll take this from the skeleton. Foot of page 49, Lord Halsbury said, once it's been found, as in this case, that the occupation cannot as a matter of law be beneficial occupation, that's the end of the question. Here there's no possibility of beneficial occupation in the County Council. They are incapable by law of using it for any profitable purpose. They must allow the public the free and unrestricted use of it. So the gist of the circumstances in that case was that it was held on trust effectively for the public, and that precluded as a matter of law there being beneficial occupation. My learned friend Musleen took the court to the Winstanley case for the purpose of submitting that actual occupation in itself is not sufficient to be beneficial occupation.
I'm being slow. Can we go back to paragraph 40?
Yes.
Because Miss Lee was submitting yesterday that one mustn't conflate the first and third requirements of Lang.
Yes.
Actual and beneficial occupation.
Yes.
I imagine you accept that.
Well, that's exactly the point I'm coming to, but yes.
Because it's the way you put 40.
Well, the
occupation will be beneficial where the occupier has some actual occupation. I'm then looking to see what you're adding to make it beneficial. And all you're adding is it's capable of generating a benefit. There doesn't actually have to be, but you're deriving that from Brockwell, where clearly if you've got as park, it's capable of being beneficially used. The occupier was the local authority. The public couldn't be treated as occupiers. But it was the nature of the public use which prevented the local authority from having any beneficial use of the park. Another park might be in the beneficial occupation of the actual occupier. So I'm not sure I understand. Brockwell Park, as I read it, doesn't support the way you formulated 40. 40 perhaps might be based on those cases, I've forgotten the name of it, the 1907 case. It's in the bundle. Melody. Where you are able to use property, but you choose not to do so.
Can I take the court, please, to so I hear what my lord's saying, and the focus is on the potential benefit. It has to be the potential benefit as distinct from being precluded. So the traction on beneficial occupation in the Lambeth case is there's a potential benefit or there's a preclusion of having that of the
legal arrangements of the park
precluded. Yes. And those are two sides of
the dock cases.
Those are two
you
sides.
see an act of Parliament which precludes making money from the docks.
So
in
that's-
the public interest.
That's one of the
That's still
established.
beneficial occupation.
Forgive me, that
That's can be beneficial occupation, can't it?
I don't think it can be if it's a
If the
preclusion.
legislation precludes the levying of tolls and so on.
So, but it doesn't. I don't have that case immediately in mind.
House of Lords
But
authorities. Anyway, I'm putting down a marker on 40 that I don't quite get it. At the
so my response to the marker, if it helps, is that the focus is on the potential for a benefit. That's the concept that's operative for the purpose of beneficial occupation. But that's Lambeth. But I need to go to Winstanley because my lord just put to me, and I'm accepting. Do I accept the proposition that beneficial occupation has to add something to actual occupation? Yes, I do. There are 4 land requirements, not a fusion of 3. But the critical question is, on the authorities, what more does it need to add, and how is that assessed? And that's the point I'm keen to focus on. So my learned friend Lee went to Winstanley for the purpose of saying there needs to be, if you like, separate consideration of beneficial occupation. I accept that, but she didn't go to the part of Winstanley where the House of Lords opine on how you approach beneficial occupation, and the court will find that it's in our skeleton in extract. But I would like to please turn it up if I may. So that's in the authorities bundle at page 66. The very top of page 66. This is from the speech of Lord Atkinson. The court may recall the facts of this is to do with the putative occupation by a member of the clergy of a burial ground. If I pick it up at the end of the first line on page 66, whether this occupation is a beneficial occupation, a thing of value within the meaning of the Statute of Elizabeth, or not, depends upon whether the occupier is or is not by law debarred from deriving any benefit from it. If it is merely by his own volition and not by the law that he is deprived of a benefit which he might have received, then there is a potential benefit and he is liable to be rated in respect of it. And then the cases are cited, the Putney Bridge case and the Lambeth case. It is clear, I think, in the present case that the appellant is not debarred by law from deriving some benefit from his occupation of the graveyard. His occupation of it is therefore beneficial. So it's a very light touch concept, is my submission. It is there has to be some potential benefit from the occupation, and that is as juxtaposed from a debarring of receiving a benefit from it under a statutory provision or the terms of a trust or something of that nature.
Well, on that basis, you would say, I think, that your paragraph 40 is correct.
Yes, but in the sense of you don't get out of rating by choosing not to use it for the purposes for which it can be used.
Yeah.
Volition, in other words, is irrelevant.
Well, I'm not sure. Well, I'm going to come back to volition, if I may. But volition, as it's used here, if you like, a choice not to quantify your value or to a choice not to utilise the benefit that could otherwise be derived is in itself sufficient for beneficial occupation in these circumstances, certainly. And so that's why I frame paragraph 40 as beneficial occupation can be satisfied by the potential to receive a benefit. Now, I take my lord's point that the way it's precisely defined in paragraph 40 might elide actual occupation with that. Actual occupation is not an issue in our case, but the focus is on potential benefit. Is on benefit, and I say potential benefit is one of the foundations of that. So, and that is the decision of the House of Lords. So that is, I respectfully say, a binding dicta on the scope of beneficial occupation, accepting, of course, that its application is contextual.
Where do the words in quotation marks, potential beneficial occupation, come from? They have a context. It might be Putney Bridge and it might be Lambeth Overseas. but I'm not expecting an answer.
Well, can we see if we can help on that
Yeah,
whilst I
okay.
carry on? But thank you.
Well, if you're homing in on the words of one of those speeches, can you show that the others agree?
Page 7.
Yes, so yes, page. Yeah, I think it's unanimous. It's the only speech.
Single speech.
Page 70.
And Lambeth Overseas, is that Shropware Park?
Yes.
So we've got that.
We have Putney Bridge, I think. Is it Hare?
Yeah. Have we got that? I wasn't going to go to that one. But,
Oh, and maybe I looked at it myself.
I'm not sure we do have it.
No,
It's
I
not
looked,
in-
at it myself. Yeah.
So that's the first theme, and I pin my colours to the House of Lords authority in Winstanley. I mean, paragraph, just to finish it off it by reference to the skeleton, I mean, there's a sort of practical application of that in relation to a car park in the Lands Tribunal case that's referenced there, which is tab 12 of the authorities bundle. I don't think we need to turn it up, but the short point is you can't argue that a shop or a car park is not in beneficial occupation if it's operating at a loss or if the parking is free, if there is a potential benefit to the occupation of it. And as I will go on to submit, the touchstone of that in the authorities is not some objective evaluation of value in a vacuum. It is there actual or potential value to the occupier from the occupation? And that I'm going to come to that, but that's how I say that question needs to be approached.
Sorry, value or potential value?
Potential value, yes. The second theme is in our skeleton, picking it up at page 46, that to be beneficial, occupation needs to be undertaken for the occupier's purposes. Now, my learned friend Miss Lean took the court to, well, actually, before I go to, so she took the court to Mr. Justice Jenkins' speech in Lang, and I will come to that. But before I come to that, can I just set the context in the stages that we are in the skeleton? So we make good that proposition in part by reference to Rye, which is the leading textbook, and we've had some discussion of that already. But can I just ask the court to re-look at that extract? So that's right at the back of the bundle of authorities. It's authorities bundle page 589. And the proposition that I rely on is encapsulated in the last full sentence of page 589. The series of cases quoted, and it says these cases show that beneficial occupation does not connote pecuniary profit, but in order to create liability to rates, beneficial occupation is necessary if by that term we mean an occupation which serves a purpose. And then there's footnote 7 that we've discussed, which has got some cases such as Erith and Jones and Mersey Docks, but it also references the LCC and Hackney case, which is where there's effectively abandoned property of no value. So that's not an assertion of ownership that serves a purpose. It's not in fact an assertion of ownership. Of occupation.
But the main cases cited there, Erith and Jones, as I recollect, certainly Erith, are cases where there was a statutory duty being performed.
Yeah. So that's the sewer. Is that the sewer case?
That's
that
the
might
sewerage case.
or the common example, public toilets, where there's no charge, but there's a value.
Or the education authority.
Yes.
Providing a school.
So it's not a pecuniary concept.
In fact, the House of Lords referred to exploding the myth that profit was necessary to rating.
Yes, because people refer to business rates as a colloquialism, but that's misleading. It's non-domestic,
Yeah.
and so it encompasses a broad palette of possible uses.
In fact, that point is picked up at the end of the same paragraph.
Yes, I mean, but we're we are not in that category of case. We are arguably in a category of case where the relevant juxtaposition is there a point to the presence of those boxes? Does it serve a purpose?
Are you suggesting though that serving a purpose is a complete definition, a sufficient definition of what we mean by beneficial occupation?
It is part of the established concept.
Yeah.
I'll draw the threads together at the end,
Okay.
but it is on the authorities. It is a critical part. I'm going to go to Lang
Yes, but it's
next.
got to be more than a purpose to qualify as beneficial occupation.
Well, we'll need to examine that. I'm not sure, my Lord, I accept that. It has to be the occupier's purpose. I don't think, my submission is that the authorities do not confine that concept beyond that it has to be of value to the occupier. Obviously, there are cases where the occupier, if you like, disowns the value, but there's potential value, and those are where we get into the potential benefit. I don't submit we're in that category of cases. I submit we're in the category where there is a value to the occupier of the occupation. There is also a motive, but the purpose is the act that is done, not the reason why it is done. So there is a value to the act which is done, which is placing the boxes in the office for that 6-week period. That is of benefit to Pol.
Okay, but sorry, just to make sure I understand, this is the second of your themes.
Yes.
The first one, which I read as a separate theme,
Yes.
is I've written down as value or potential value.
Yes.
That seems to me to be put as a separate point to purpose.
What may I?
I'm
I'm going to tie them together. I'm actually I'm going to show this is a extraordinarily broad concept that has been developed under a series of cases catching rateable occupation that instinctively there's a reason for arguing things aren't. Then there's now been a reversal of roles. Our job, I say, is to deploy the same case law, but on the other side of the debate, because that's what Regulation 5 does. And so therefore, whilst all of this was catching occupation, I submit it catches what Pol is doing for the purpose of Section 43, and if that's right, it also therefore gives the
but the reason one of the reasons I'm asking is if you say, well, occupation for a purpose is enough, that doesn't necessarily then explain the Brockwell Park type cases.
unless
You've got to have an additional.
that is not occupation for a purpose that is not precluded. I would submit is explaining the Brockwell.
In the sense your local authorities occupying Brockwell Park in order to maintain it for the benefit of the public. There's a clear purpose there. Maybe maybe this attempt to rationalise in different ways like this actually falls down when you. It doesn't. Maybe it's a way of helping to understand some cases, but not an overarching set of rules.
Well, I mean, obviously that's a point on which the court will have to wrestle. My submission.
But do you see my point?
No,
about
I
the
do.
local authority of Park? I'm struggling a bit.
I do, and I'm trying to just orientate myself in our skeleton, because we do attempt to draw the various threads together. I'm still, if you like, developing the threads, but the way that they are drawn together, if I could just
Well, you do try to draw the threads from 57.
that's exactly what I was looking for. Thank you, my lady. So drawing the threads together, an actual and exclusive occupation, which is deliberately undertaken for the occupier's purpose and is not referable to abandonment, and where the occupier is not debarred from receiving a benefit, is an occupation that meets beneficial occupation. So we're trying to patch together those cases to that overarching proposition that we say is consistent with the boundaries of beneficial occupation. I think I would add, adopting what's put in Public Health England, that mere caretaking is also not an occupation, which is a slightly broader concept than the not abandoned. But my lady, that's how we say you do patch it together. I'm sorry if my oral submissions were less clear than that encapsulation in paragraph 57. May I pick up the second theme again and show the court what is so we refer to Melledew and the judgment of Mr. Justice Farwell, where he talks about using the premises for the purpose of his business. Now, I accept that that's a warehousing case; it's a specific context, and there was a factual judgment about the fact that the warehouse person was holding it open for the purpose of his business, and we're not in precisely those facts, and Melledew is a different case that perhaps shouldn't be taken too far out of context. But that's why I'd respectfully suggest the terra firma is Lang, because Lang is where the central concepts actually get articulated. So if we go to Lang, which is page 90 of the authorities bundle. Now, Miss Lean took the court to this, but I have something to say about submissions in relation to it. So it's at page 90 of the bundle of authorities. And can I just, we all talk about the Lang requirements. The Lang requirements are the adoption of Mr. Rowe's 4 factors. I could just show the court, just to note it. The actual record of the submissions is at page 81, and the way the case was put, which was accepted by the court, is at 81. Thirdly, so it's 5 lines down. Thirdly, the possession must be of some use or value or benefit to the possessor. That was the broad formulation. The court expressed it virtually identically. It expressed it.
81.
81. But starts 5 lines down, halfway through. Thirdly.
Yeah. Yeah.
So I could go to
I noticed just below that it refers to Southern Railway, the case about Victoria Railway Station, the concourse. And halfway down, the Southern Railway case unquestionably altered fundamentally the way in which occupation cases were dealt with. Might be necessary to have a look at that.
So, sorry, my lord, where was the fundamentally?
Council's submission.
Yes, but it was a very thorough review of. Have you looked at that?
No.
Did you get any benefit
So,
from it?
I'm familiar with Southern Railway, obviously, but
Yes, so we've had it recently.
Yeah, my lord, my learned friend who is more composed in the moment than I suggests that's critical to the question of exclusive occupation.
Okay.
It's not
Yeah.
really
It
about
was
beneficial,
dealing
and
with
that sounds
paramount in
yes,
occupation.
yes, and that sounds like a very helpful observation. So
It doesn't deal so much with beneficial
yes,
occupation.
I was going to go to Mr. Justice Jenkins with that. That was where Miss Lean took the court, and this is where the point is put quite pithily. So it's at 90, and again it's thirdly, and this is a supporting judgment in the leading case. Thirdly, it is said that possession must be of some use or value or benefit to the possessor, and that's entirely consistent with what I showed you. The formulation was in Mr. Rowe's argument. But as to that, it seems to be enough to say that the contractors occupied those premises for the purpose of their business. Pausing there, that's the positive case that we advance. But then Miss Lean invited you to read something into the qualification or what followed, and it seemed to me to be quite immaterial that their business in this connection consisted of the carrying out for award of a particular construction project. Now, that point is, I respectfully say that those additional words about immateriality are a reference to the argument in this case, which is not something we're concerned with, but which focused on, if you like, whether there was a special approach to building works or construction work generally. And the reason I say that is if the court goes to page 79, the argument on behalf of the ratepayer challenging the decision. So it's 79 on my version. Sorry, this doesn't help my lady. I was going to say it's by the lower hole punch, but so it's 2/3 of the way down. Number 3, where a contractor goes onto land to do work for somebody who until then was the occupier, was said to be a special case, along with lodgers, etc. And then over the page, 80, it was said the contractor cannot exclude the again, sort of 3/4 of the way down. The contractor cannot exclude the building owner from the site or these particular buildings. For all practical purposes, he is doing nothing more than a servant using special tools and machinery and doing something for the building owner on the building owner's land. So there was a particular argument there about effectively the quality of that particular occupation being linked to construction and or servants, and that was rejected as relevant. Now, as I understand it, that's a line of thought that found expression in a later House of Lords case, which is quite well known, called Arbuckle-Smith, that effectively stands for the proposition that the upkeep of development of property does not in itself constitute rateable occupation. And that's not in the Bund of Authorities, but you do get a helpful summary of that within the Public Health England case at paragraph 34. So can I just show the court that? Because that's my understanding of the issue that Mr. Justice Jenkins is.
Yeah, on the facts of Lang, though, the question was related to a certain bit of the compound, isn't it, that was effectively set aside.
Exactly, it had exclusivity.
So there wasn't a direct, the point you've just made wasn't directly in point.
But it was advanced, and it was rejected
I
for
know,
that reason.
I'm just trying to.
Yes.
The facts of Lang, it's a part of the compound that's set aside for that.
Yeah, so on the facts of Lang, there is rateable occupation. Exactly, the 4 ingredients align to that part, and it doesn't defeat rateable occupation. That it's the business of construction. So
okay,
that's
not very surprising, is it?
It's not, but the only reason I'm taking the court to this is that my learned friend Ms. Lean was relying on those extra words. It's immaterial. My submission is they're understood as saying there's no special case to see here, effectively. So that means the operative concept of beneficial occupation is advancing the purposes of the occupier, and the qualification is nothing.
The occupation of the contractors' huts by the contractors was a beneficial purpose to them.
To them, yes, for the purpose of they were occupying for the purpose of their business. Yes, and it's as simple as that.
The construction site as a whole was not rateable, was neither here nor there.
Because they carved it out. But the reason that there was even that qualification was because there is a line of thought. There's special rules for things under construction.
Principle for contractors' huts was followed up by the House of Lords and LCC.
It certainly was, yeah, and it was applied.
Anything useful there?
We haven't brought that to the court, so I can't.
You are going to take us to a summary of our buckle.
Thank you, my lady. Yes, that's page 409, please. Sorry, 419. Sorry, it's paragraph 34. So this is from the judgment of Mr. Justice Carr in the Public Health England and Harlow case, and it's paragraph 34. The possessor's purpose must, however, go beyond the upkeep or development of the property itself. Thus, presence and use by a caretaker does not amount to occupation. Arbuckle-Smith is cited, and then further there must be an intention to that's going on, I think, to a different point, but it encapsulates the points I've been developing here. But it's the concept of beyond the upkeep and development of the property itself. Mere maintenance is not enough. And Arbuckle-Smith itself is to do with if you like, getting a property ready for occupation, as distinct from occupying. That's right. And then actually, whilst we've got that paragraph 34 of PH Public Health England in mind, that's the point we develop at 53 to 56 of our skeleton, that there's the two sides of the coin are, is there abandonment, is there worthless property or caretaking, against does the property manifest an intention to occupy, is it an assertion of occupation in itself?
Going back to Arbuckle Smith, that was a warehouse, wasn't it?
Arbuckle Smith.
Arbuckle Smith and the House of Lords. And it was being converted, it was being redeveloped
Yes.
into a bonded warehouse.
Yes.
And whilst all the physical works were being carried out to make it capable of being used as a bonded warehouse, there was no rateable occupation.
Yes.
It couldn't be used according to I think the words in the law report are, according to the nature of its user, or its use.
But although one has to be a little bit careful, that was because it was under construction. In the Sterling case, Mr. Justice Wilkie made it clear, and I submit correctly, that the concept. So once a hereditament has come into existence and it exists, then the question of whether it does exist is, as my lord will recall, judged by reference to the purposes for which it's intended to be occupied.
Yes.
If it's come into existence, it's a hereditament, and you occupy it other than for the purposes for which it's intended, but you're occupying it. So, for example, using a Bluetooth receptor in a warehouse is one example. Storing boxes in an office might be thought to be another example. The fact that you're
I have to say I have a little bit of difficulty in understanding how putting a Bluetooth receptor in the warehouse is using it according to the nature of the use, i.e. as a warehouse.
It isn't, but can I show? Because that was argued by that was argued before Mr. Justice Wilkie by Tim Mould, King's Counsel, as it was, by very careful reference to authorities. I'm happy to take a moment to go to that.
I won't take our time now.
May I won't do it now, but I've got the references. So can I feed the references to at the end? When I'm sitting down, I'll note the references and just give them to you, because that may help. But there was it was very carefully put, and Mr. Justice Wilkie adopted Mr. Mould, Mr. Mould Casey's, as he then was, submissions on that by reference to authorities. It is quite helpfully set out in that judgment on exactly that point. And I think we actually, I think also, my lord, we do actually deal with that in our skeleton. So it doesn't quite do justice to it, but paragraph 68 of our skeleton gives you a signpost to paragraph 74 is where Mr. Justice Wilkie draws it. But if the court looks at the way Mr. Mould formulated it, it's dealing exactly with that point, and it's not the requirement that the occupation relates to the purpose of the hereditament. Forgive me, the intended use of the hereditament. So the third theme I think I've covered, which is abandonment versus a manifestation of value. May I then come, please, to my Lord or Justice Holgate's observation about the proposition about contingent benefit, that the proposition is it truly to be beneficial occupation in the circumstances of this case, where it said the benefit only arises after the completion of the 6 weeks, and that is a contingent benefit. Now, exactly that point was carefully considered by the High Court in the Public Health England case, and the relevant paragraph is paragraph 62 at page 422. So I just pick that up I think at paragraph 60, I reject the proposition that no benefit accrues to a possessor motivated by the prospect of a rates exemption until the occupation has ceased. Pausing there, the use of the word motivated is, I'd respectfully say, deliberate, because Mr. Justice Kerr has in mind the difference between purpose and motive. The reasoning is choristic, if I pronounce that correctly. So I think, I think it means casuistic. Forgive me. So it's
about sophisticated
over sophisticated, over elaborate, effectively, over elaborate reasoning.
Gratuitous philological exhibitionism.
Indeed, I apologise, I stumbled over that word. Rate of occupation is indeed determined under the legislation on a day-to-day basis, but that same legislation aggregates days of occupation into periods of occupation, and an occupier must wait until its exemption crystallises, does not stop current occupation conferring the present benefit of notching up another day of the period that will produce the exemption. So he thought about that point, and I respectfully say, if one approaches that through the established approach to...
Sorry, and in that particular context, another day of the period, was that the 6 weeks?
Yes, it was. Yes, it was. That's a reference to Regulation 5, the 6-week period. I respectfully say that that's consistent with the sweeping approach to beneficial occupation. There must be a benefit to the occupier. It can be indeed a potential benefit. My submission is this isn't a case of potential benefit. This is a case where the occupation serves the purpose of the occupier on every day of the occupation. And my learned friend's going to come. My learned friend Mr. Wilcox will come back to Francis, which also potentially bears on those kind of questions. So I do. So those are the main issues in terms of the main points in relation to beneficial occupation. I do maintain the way that the threads are drawn together in paragraph 57 of the skeleton. I do submit that actually the consistent approach to this in the High Court is of note. These points have understandably been rigorously argued with experienced counsel before first instance judges, and 4 times the point has been reinforced, and it is not self-evident that macro would be extended in the way that it potentially was in Principled. But what's happening is again, incredibly pithily summarised by His Honour Judge Jarman, the reversal of roles under the legislation is having effect, and the legal consequences are flowing from that. And I come back to the idea that's not an inevitable feature of any statutory scheme, but that is a feature of this statutory scheme maintained by the Secretary of State for the time being. I commend to the court the way in which all of the High Court cases have drawn these points together. I don't want to take undue time on that because I've gone back to the source case law, but may I just offer these thoughts on the concept that troubled my Lord Justice Holgate of volition as the watch as the basis of rateable occupation. Now that's all dealt with quite carefully in the submissions that Mr. Mooreshead made to Mr. Justice Kerr, and he went through, for example, the case of Winstanley.
Are we talking about Paul and Trafford here?
Paul, yes, sorry, my lady, yes, we are. I respectfully submit that the concept of volition, which was the way that it was put by counsel in that case, is an amalgamation of a series of thoughts. So volition includes.
So which paragraph is it?
In the submit. So let me go to the decision. Sorry. So paragraph I had in mind is starting at paragraph 78. 78 to 80 in particular. So the submissions are formulated between 78 and 84. So established approach to beneficial occupation in 78. The verb stored connotes a purpose beyond the placing of goods within the property, going beyond the purpose of occupying it to enable the landlord to escape rates liability. The billing authority has indeed stated that the claimant company needs to explain the benefit of storing them and explain in detail how these goods are to be of benefit. So that was he's recording the submissions of the billing authority. Whilst the billing authority accepts the storage of goods for an independent commercial purpose, as in macro amounts to rateable occupation, it does not accept that the mere presence of the claimant company's goods for the sake of populating the premises for rates mitigation can be rateable occupation. Counsel for the claimant company's submission is that placing goods in a property to occupy it is beneficial occupation. The act of volition is the hallmark of occupation. So that's where that idea comes in, and then he gives examples of the whimsical, eccentric, and analyses the difference as being a difference of motive rather than purpose, and that's a formulation that I rely upon, and I say it's consistent with the understanding of the difference between motive and purpose that we get from Lord Justice Lloyd in the Wimborne case that my learned friend Miss Lean showed you, and also we get some insight, as I'll come to, in Robinson Webster, at I think it's paragraph 69 on precisely that point. And then 84, the claimant company's argument is that the authorities on rateable occupation going back to Victorian times supports this approach. And the authorities on rates avoidance in recent times show that the law may not be distorted in order to prevent avoidance of tax by lawful transactions. It's therefore sufficient that the claimant company is the exclusive possessor of the properties and that they are populated with goods of some thought. So that's the submissions, and then it's brought together in the decision of Mr. Justice Kerr.
So just going back to 80.
Yes.
The act of volition. What does it mean?
Well, I as used by Mr. Mooreshead, means the active assertion of the placement, the conscious placement of the boxes as an assertion of occupation which serves the purposes of the rateable occupier, would be my submission.
But normally in rating practice, people don't bother to talk about volition. They talk about what is actually going on.
Yes, but
you don't bother to ask the question, well, was this done deliberately or was it an accident?
No, but you might need to differentiate. Well, you might. Well, it certainly is relevant, I'd submit, if you're differentiating between the mangle in the cupboard in the Hackney case, which is leftover, and the utilisation of property that is said to constitute occupation. The fact that it has been put there with an intention of occupying is captured in that concept of volition as the flip side of
it seems
surplus
to be
to
a
requirements.
concept which is being used when people have left for the days of unoccupied property taxes. People have left property relatively sparsely populated, or not much in the way of artefacts, and the question is whether or not that's sufficient to count as beneficial occupation, like a house, for example, with furniture in it, or a warehouse with very little in it, but it's capable of being used as a warehouse.
Yes.
The fact you choose not to it's like it's put the other way around. The fact you choose not to make use of it, that doesn't prevent you from being rateable.
Yes, although in macro is where this idea first started. There's discussion of some of the key points about the difference between a seaside house that's shut up, etc. My submission on volition is that and I'm not. I submit this is consistent with the way it was advanced in poll. My encapsulation of it is that it's a shorthand fusion of a number of ideas. One of them, perhaps the most obvious one, is the flip side of abandonments. So that what's there is there consciously and deliberately, and that is something that is discoverable from its presence, because when you look at it, you can objectively ascertain that the effect of it being there is occupation. That's what's encapsulated in that. It's also consistent, volition is consistent with the idea that there's no debarment to occupy, because on the authorities, if you had volition of doing something that you were debarred from doing, it wouldn't be occupation, because the debarment would prevail on the authorities. In the macro case, the concept of intention came in. My lord, I say that's not misconceived, but it's confined, I would respectfully say, to the differentiating the abandonment from the deliberate presence.
Abandonment is a term used in the Lands Tribunal decision given us, Ministry of Transport against Holland.
Yes, which goes back to the case of Hackney, which is cited there.
Abandonment
where it
is
comes
referred to originally there.
Yes, yes.
In what sense is abandonment being used? Because it crops up in various areas of the world.
Well, in the sense that the things that were left, worthless things were left over, and therefore, that objectively, they didn't amount to an assertion of ownership. An assertion of occupation. That's the sense in which it's being used in the authorities.
It's the converse of intention.
Yeah, it's used as the converse of intention is the way.
Yeah.
Well, Mr. Justice Carr puts it very clearly in PHE in Harlow 34 and 35, or indeed Colin Trafford. Two exceptions. Caretaker, just keeping the place safe.
Yep.
Smith, that doesn't count. Abandon something because it wasn't worth the trouble of removing it. Hackney. Otherwise, plant your flag. Doesn't matter what it is. Could be pizza boxes, and that's it. And even if the only reason why you're doing it is rates mitigation, that's fine. That's beneficial occupation. That's what we have to decide.
Yes, in my submission, that's the motive, and that's irrelevant. I mean, it may be capable of informing some element of it, but it's not a sufficient reason that the motivation is rates avoidance on the existing authorities. And my lord, I don't hide from the fact that might be seen as an unattractive outcome, and it might be seen as a counterintuitive outcome, but it is the logical and legal consequence of the voluntary linking of this to the concept of occupation as previously understood, which is absolutely within the Secretary of State's gift to disentangle. So that's may I move on from rates of occupation? I was going to cover Wimborne, but my learned friend Miss Lean went to that. I do say that the Wimborne insight of Lord Justice Lloyd it helps the court to be precise about the terminology of purpose and motive, and the encapsulation there. It's Authorities Bundle 213, but the point is it's what somebody does in their purpose, and why they do it is their motive. And so the language of purpose of rates of mitigation is actually imprecise. And my submission is the ratepayer's purpose is the placement of boxes into the property for a 6-week period as an overt act of ownership for the motive of rates mitigation, but the motive is irrelevant. It is for the purpose of its business that is relevant. It serves its purposes to place the boxes there. And that's just to orientate that in our skeleton. We try and encapsulate that at paragraph 118 of our skeleton arguments. But may I move on? I'm going to come to Rossendale. Before I come to Rossendale, may I, with those submissions in mind, just invite the court to go to Core Bundle, page 16, I want to make an observation about the very shortly framed ground of appeal that's before the court. So that the court obviously encourages concise drafting. This certainly does that. But within that concise drafting, I say we can actually now see two fundamental misconceptions hiding in plain sight. So the judge erred in failing to hold that the application of the Ramsay principles meant that on a purposive approach to statutory interpretation, the placing of boxes for the sole purpose of rates mitigation and avoiding the liability which would otherwise arise did not fall within Regulation 5. Now, I take issue with two of the core concepts there. Firstly, the purpose of rates mitigation, because properly understood through the prism of Lord Justice Lloyd and through the prism of Lord Justice Holgate and Mr. Justice Mould in Robinson Webster, we have to be careful about differentiating between purpose and motivation. This is the motivation of rates avoidance. The purpose is for the ratepayer's business, and one has to be more precise. So, in fact, one could say the placing of the boxes for the purpose of the ratepayer's business, that would be that would be right, but that would take you to a different place on the authorities. It would take you to the fact that they're occupying for the benefit, for their own purposes. But here, the concept of rates mitigation is elided with the concept of motivation. So that's one fundamental concept there. The other one that I take issue is this loose concept of avoiding the liability which would otherwise arise. And may I just take a moment on that? So if property is occupied for 6 weeks, liability for those rates, for rates in that period, arises. It arises under section 43 of the Act, and for all of that 6-week period. A 6-week period of such liability then triggers the reset provisions if one gets past the 6 weeks, which govern when the property is treated as becoming unoccupied for the purpose of 4.1. But if it does use that, then it's not a prescribed hereditament for the purpose of section 45 due to the combination of Regulation 5 and Regulation 4.1. If it's right that property is taxed as it stands, according to whether it is in fact occupied or is in fact empty, then the scheme doesn't involve any counterfactual deeming, as I've shown you, because that would be a limited exception that's not in play, then the loose concept of liability that would otherwise arise in fact relies on an immaterial comparison, because liability is determined in accordance with the factual state of the property on any given day. How the property might otherwise be used is irrelevant, or not used, is irrelevant under the statutory scheme, absent special conditions. So my submission is that's imposing a normative assessment that is outside of the functioning of the statutory scheme. So that ground of appeal is actually built on examination on two misconceptions.
Well, yes, clearly on your case, but it does rather beg the question.
Well, yeah, it begs the question about occupation. It doesn't, in my respectful view, it doesn't beg any questions about the functioning of the statutory scheme. If you are in if you take the benefit of Regulation 5, you don't avoid liability. Liability does not arise under the statutory scheme. Those are two different concepts. One is legally accurate, the other is an inaccurate colloquialism, and this ground of appeal is built on an inaccurate colloquialism, in my submission.
I would accept that perhaps the words avoiding the liability which would otherwise arise add in the 3 months after departure.
But my submission is the concept of counterfactual, what would otherwise be, is not a relevant concept under the statutory scheme properly understood, unless where the legislators make it so, and here they haven't made it so. So what's happening here is that we are organising arrangements in accordance with the boundaries that Parliament have set that's not avoiding liability. The liability just doesn't arise. And that's because and the reason I say there are two fundamentally flawed ideas are very shortly that motive is irrelevant on a proper understanding of the case law, and so too is what could be done but is not done. That's irrelevant. What matters is what's done and how that functions under the statutory scheme. May I then, before I get to Rossendale, may I just deal very briefly with the PAG case, which is the decision of Mr. Justice Norris, which the court will find at tab 22 of the bundle of authorities. We deal with this in our skeleton argument at paragraphs 83 to 86. My learned friend Mr. Forsdick touched on this briefly, but in my respectful submission, I just need to reiterate to the court what was decided here and what wasn't. So this is a winding up case. It comes before the High Court. There are it concerns a scheme that's similar to Rossendale, the use of special purpose vehicles and use of a member's voluntary winding up. And it was attacked on a whole host of bases by the Secretary of State under the insolvency legislation. It was decided that there was an abuse of the insolvency regulations, which you'll see the conclusion of which is expressed in paragraph 69. And so on that narrow basis, the winding up petition succeeded. But there was a much broader issue, a much broader point at issue, because there was an attempt to say that it was contrary to the public interest to undertake rates mitigation, and that's the point that was quite carefully analysed on the evidence in the decision of Mr. Justice Norris, and that's the point that one picks up at page 302 of the bundle, starting at paragraph 55. And so Mr. Justice Norris says, I do not consider the court can conclude on the evidence or in principle that the particular rates mitigation scheme offered by PAG is by its nature contrary to the public interest. And then he argues, he records the argument proceeding on the assumption that avoidance or mitigation is inherently bad. It was common ground before me that both the alterations in empty rates relief made in 2008 and the steps taken by property owners in response had generated concern. He then refers at 57 to the concerns about, if you like, rates avoidance, rates mitigation, and then at 58 and 59 he refers to the evidence referred to by PAG's management, and that's to the effect at paragraph 58 that business rates themselves are having an adverse impact on retail businesses in the high street, and that in their current form that committee said they're not fit for purpose. But then
isn't this a bit of a jury point?
well, I'm not sure the next paragraph is, with respect, my lord, if I that point is context, but it may be jury context. I accept that. I submit 59 isn't. 59 is quite an important insight for the purpose of my argument, and it certainly influenced the judge below, and I say rightly so. So the evidence of PAG was, he explained that before a landlord could refurbish his premises, it was necessary to take back units that were in occupation, but it was not possible to obtain possession on all units simultaneously. According, some units had to be taken back and then held void pending assembly of the remainder of the site. He said that using a rates mitigation scheme in relation to those void units lowered the cost of refurbishment scheme and gave the landlord the confidence to go ahead. And then he gives the concrete example. And the concrete example effectively is that a building that was empty was on the verge of demolition. They then used a rates mitigation scheme That then allowed it to be marketing for a longer period. That then led to it being refurbished and converted into a Premier Inn. Now that is the absolute embodiment, I would respectfully say, of the fulfilment of the purposes of empty rates. It is encouraging a vacant property back into a beneficial use, but it is doing it via the practical use of a rates mitigation scheme to mitigate the otherwise significant impacts of the fiscal scheme. So the insight that brings is that a measure which is completely under the control of the Secretary of State and which on the evidence has been introduced back in 1966, first of all, when it applied, one of the motivating factors was relating to empty houses. It's then controlled by the Secretary of State from 1989 onwards. You've then got a very significant expansion of this in 2007 and 2008. Mr. Forsdick's taken you to the economic context of that. That's pre-financial crash. It's all about property prices are rising. People shouldn't be holding it, rending a rising market, etc., etc. It's then implemented, and then the incentives it creates, bringing it back into occupation, start to have effects that are counterintuitive. And they've had those effects for over a decade. No action has been taken by the Secretary of State. This goes to why that might be. And one of the reasons why it might be is they might actually be causing some good as well as some harm in their practical implementation, which is why Mr. Justice Norris expresses himself that actually solving this involves difficult political and social economic balances. And that, in my respectful submission, is an important insight. Now, the argument before this court is predicated from the City of London on the idea that mitigation per se is costing the public purse a fortune and damaging the economy. This suggests the position might in practice be significantly more, to use the judge's words, nuanced than that, and that there might be some instances where rates mitigation happens to actually be serving directly the underlying intentions of the statutory scheme and helping to bring property back into beneficial and enduring use. That's why it's important, my lord, because this is, as I've submitted a couple of times, this is an inversion of Ramsay. Ramsay is about Parliament can't keep up and it's obvious what to do. This is the Secretary of State's all over this and it's not obvious what to do. That is a very different category of case to Ramsay. So that's POG, and then may I then turn to Rossendale, and then I'm going to go to Barclays after that. And I'll go through Rossendale as quickly as I can, but the court, I appreciate the court's familiar with this, and that my Lady Justice Falk and my Lord Justice Holgate have been involved in decisions involving this. May I? But I just want to take time to go through it as quickly as I can. So if I could go to the judgment, it starts at the bundle at page 439. The facts on Rossendale, which are well known, but to state the point, obviously, they concern property that was observably empty, and there was no other analysis about what was going on other than that this was empty property, and there was an issue about who, if anyone, is the owner for the purpose of section 65(2). In the particular circumstances of the case that are summarised in paragraph 4, there was held to be breaches of the insolvency legislation and the commission of a criminal offence in relation to the dissolution version. That's the factual context of Rossendale. I fully accept that in Emerald Shore that's not a necessary precondition for the application of Rossendale, but that's the circumstances which were presented before the Supreme Court. And as encapsulated in paragraph 3, both of the schemes effectively relied on, for their effectiveness, on administrative inertia. So in other words, nothing was happening physically in that property, but there was a legal question of where actually the responsibility for making that property available for use lied. And the Supreme Court gave a purposive interpretation to who the person entitled to possession is under section 65(1), which aligned, as it happened, with the facts on the grounds where the property was empty, and the question was who had the practical control to make it available for use. In so deciding, the Supreme Court dealt in some detail with the approach to statutory interpretation. If I could pick it up at page 438, paragraph 10. They forgive me, actually, paragraph 9. They make the point that although the Ramsay principle, this is at paragraph 9 by letter D, although usually deployed in relation to tax avoidance scheme, it is not in its essentials particular to tax legislation, to tax, being based upon the modern purposive approach to the interpretation of all legislation, one which penetrated the field of tax legislation only at a relatively late stage, and that's a reference to, amongst other things, Barclay's Mercantile, which we will come to. There's then paragraph 11, sorry, the general assumption. So if you're picking up at letter A, it is because it's not generally to be expected that Parliament intends to exempt from tax transactions which serve no purpose other than tax avoidance. So that's the general approach and the general working assumption, but how that applies in any given circumstances is a matter of detailed application of that.
You wouldn't dispute the general proposition.
Beg your pardon?
You wouldn't dispute the general
No,
proposition.
but the judge below, I'd respectfully say, was right to say that's the general rule, that how it applies in any given set of circumstances requires a focus on the statute as a whole and the relevant statutory conditions. But I don't dispute that general principle, but it does need to be understood through its orientation in Barclays, which I will come to. Now, at paragraph 13, this is again the emphasis of an endorsement of the judgment given by Lord Nichols on behalf of the whole of the House in Barclays Mercantile. The Ramsay line of authorities is an application of the general principles of statutory interpretation, and there's then a reference over the page to Arrowtown. The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. And that's a helpful encapsulation, as it happens, from a Hong Kong case, but that's brought into the jurisprudence through Lord Nichols in Barclay Mercantile. And the ultimate question, this is in paragraph, the ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. So I would say you understand the whole scheme in the light of its history, purpose, and how it operates. And then at paragraphs 15 and 16, you get the idea of ascertaining the facts that are intended to be affected by the exemption, and then discover if the relevant facts are within that class. And in doing that, per paragraph 16, you do that in the context of, I would emphasise, the whole of the statutory scheme within which it's contained, and the identification of the purpose may require an even wider review extending to the history of the statutory provisions or scheme and its political or social objective, to the extent that that can be reliably ascertained from admissible material. So I do say, if I'm right in my emphasis that there's a continuing ability on the Secretary of State to influence it. And the observations of Mr. Justice Norris in PAG are part of the relevant suite of socio and economic objectives with which we might be concerned. May I then just take a point, just break off and take a point in relation to my learned friend's skeleton arguments, because at paragraph 45 of that, he cites the case of Gilbert, which is referred to in Hurstwood at paragraph 11.
Yeah.
But it's referred to in Hurstwood by reference to the speech of Lord Wilberforce in Ramsay. And the important point I make is that one cannot take that dicta to be indicative of the approach in itself, to be indicative of the approach to construction, because read in isolation, that dicta implies, if you like, an anti-avoidance general rule. But if we look at how it came into the jurisprudence, if we go back to the case of Ramsay, just briefly, this is at page 327 of the authorities bundle. Sorry, that may not be the right reference, sorry. No, is it page 130 of the... Yeah, sorry, 327 is the page number of the judgment. 130 at the top of the page. So the Gilbert quote there is set out, but then Lord Wilberforce observes this: it is probable that this is at letter A on page 130, it is probable that the United States courts do not draw the line precisely where we, with our different system, allowing less legislative power to the courts than they claim to exercise, would draw it. So he quotes it to say this idea is in play, but he is not saying that's an encapsulation of the interpretive approach of the court. Now, I submit that that is clearly understood by the Supreme Court in Hurstwood, but I do submit it's not obvious from paragraph 45 of the City of London's argument that that limitation has been understood. You can't take Gilbert as the source of the approach to construing legislation in these courts. It comes into the jurisprudence through that qualification in Lord Wilberforce's speech. And that qualification is important in our case. It may not be that critical in other cases, but I say it's very important in our case.
The citation learned in hand in Gilbert in Rossendale and Hurstwood is longer than the citation by Lord Wilberforce in Ramsay, as the words in part indicate, and in Hurstwood they are adding. The Ramsay quotation takes you up to the law and disregard it, but in Hurstwood they are adding, for we cannot suppose that it was part of the purpose of the Act to provide an escape from the liabilities that it sought to impose.
Sorry, just catch up. Sorry, one moment.
439.
Thank you very much. My lord's absolutely right about that. My submission is that doesn't change the analysis. That's the American approach, which is not completely out of bounds in the British, the UK approach, or the English approach.
How can it be? Our Supreme Court have cited it.
Yes, but it comes into the jurisprudence in a very deliberate way.
One way of possibly squaring the circle is if you look, is to think about the purpose for which the reason that longer citation is included in Rossendale. If you have to read the context in Rossendale, it's not generally to be expected that Parliament intends to exempt from a tax a transaction which has no purpose other than tax avoidance. And that's what the additional words that aren't included in Ramsay make precisely that point. I mean, I do agree with you that Gilbert, that certainly the first part of that citation is not the authoritative statement of the Ramsay principle. The nearest thing to that is the citation from Maritime.
Yes.
Being repeatedly applied.
Yes. And I do. I do submit.
But just to complete the point, I can completely see why the Supreme Court are including this citation here, because the basic point goes back to the parliamentary intention, whatever we mean by that. We don't mean subjective intention, of course.
My only point is that Gilbert without the Lord Wilberforce qualification is an incomplete encapsulation of the way in which this applies on the facts of any given case.
Yeah, I've made my point of what I think is the nearest to the authority.
Aratam. I understand that. And that's the golden thread in Rossendale. So,
but the additional sentence that my Lord and Lady draw attention to, taken from Gilbert, in fact is reflected by the Supreme Court in its own language in paragraph 11, immediately before the reference to as judged and event, saying exactly the same thing.
Yes, the point.
And if I may say so, I may be wrong, but I do remember when we had Emerald Shore, that obviously we looked very carefully at this paragraph, and the last sentence refers to another part of Arrowtown, a passage from Lord Millet's judgment in that case, and it may be useful for us to have that, because my vague recollection is it was useful, and clearly the Supreme Court had it in mind. It's on the same lines as Mr. Justice Ribeiro's dictum. It goes a little further from recollection. I certainly intend to look at it again.
Thank you. So I think I've dealt with the broad approach. So paragraph 16, they draw the threads together. Both interpretation and application share the need to avoid tunnel vision. The particular charging or exempting provisions must be construed in the context of the whole statutory scheme, etc. Sorry, I've taken the court to that already. That's paragraph 16. I mentioned the intellectual foundation. Ms. Barclay is going to come back to that later in this decision and independently. But then may I just deal briefly with the rating context as it's explained in the Supreme Court in Rossendale. So the discussion of that starts at page 441, paragraph 18. Before we get into that, may I just draw attention to paragraph 52 of the Supreme Court's judgment. So page 451, the courts below, paragraph 52, the courts below appear to have received little assistance from counsel for the local authority as regards the purpose of the rating legislation, and the same was true in this court. So it doesn't seem as if there was detailed argument before the Supreme Court as to the purpose of the rating legislation or the totality of the rating legislation. Now, it's no part of my case to say this court needs to disagree with anything in Rossendale, but the court does, I respectfully say, have to keep in mind that the context of this is the issue that was exercising the court there, which is unoccupied property, which hasn't got any concept of occupation in play, and they didn't have any analysis of the wider scheme being offered to them by counsel. It would seem on either side, but certainly they they attribute responsibility of that to council for the local authority. So with those observations, I just go to look at the rating statutory scheme. So paragraph 18, they deal with section 45, and then they identify the owner, and then they go into the 2008 regulations and the statutory history. They observe that the 2008 regulations replace without major changes the 1989. Now that's partially right, and we know that there were actually some major changes in the sense of the approach to industrial property. So that wasn't the centre of what the Supreme Court was thinking about, but it suggests that this isn't the total analysis of the statutory scheme. Also, they don't, I think, note or keep in mind or regard as relevant in any way that the charge changed from 50% to 100%. So because they're obviously looking at the parts of this that go to prescription by reference to the identity of the owner. They then go into the historic background at paragraph 20, and then at paragraph 21 they simply note, without any discussion, the existence of the common law rules and section 65(2), which they relate back to the land requirements. So that's the only reference to occupied rates in Rossendale itself. They then discuss the purpose in terms of encouraging property to be put back into use at paragraphs 22 to 25, and they then do a broad survey of what they call the exceptions to unoccupied rates in paragraphs 25 to 27. But in undertaking that survey, they make no reference whatsoever to Regulation 5, which is a critical regulation for present purposes. So they're not alive to the potential relationship between occupied and non-occupied rates, because it isn't an issue in their case. They're not alive to Regulation 5, which is the critical provision in our case, and they're not, insofar as they touch on section 65(2), they just do it by reference to the land requirements, and they don't at any point, even though at this point it was a massive practical issue in occupied rates, they don't make any reference whatsoever to the macro line of cases because it wasn't on their radar. It wasn't on the radar for two reasons. One is it didn't relate to the issue, but secondly, they didn't have the benefit of informed submissions as to this overall context and how it played out in rating. So again, none of that is to say they got anything wrong, but all of that is to say that they actually, one needs to, I respectfully submit, take a discerning approach to how much direct assistance this authority gives the courts.
Well, doesn't it tell you that if nothing else, it confirms that the Ramsay principle, whatever label you apply to it, is most definitely not confined to tax and applies in rating.
I fully accept that.
You have to accept
I fully accept that. I don't, I mean, yes.
that, and in a way, that's what it's relied on for.
Yes.
Point.
It's also relied on as very closely to sort of give the definitive analysis of the statutory purpose, but
Yes.
in that sense, it's less
And
reliable.
on that, I mean, we must clearly have regard to that. We take, understand your submission that you say it's not complete, etc., etc. But
Yes,
we're not really in a position to disregard it, and I don't think you're suggesting.
I'm simply saying it needs some contextualisation. There's
Yes.
nothing in there that I need to challenge. I say, and I do say in my skeleton argument, that our occupation, I say, is within the class of occupations that is within the relevant facts, because the purpose, insofar as it's broadly drawn, is bringing property back into use. Once you start getting into types of use, you're straying outside of what the supporting material indicates, and you're creating an amorphous concept that the Supreme Court expressly disowned in Rossendale. I'll come to that.
Okay.
So
Now, can I just look at the clock?
yes,
It's 25 to 1,
Yes.
and you are at some point going to hand over to Mr. Wilcox, and then Mr. Forsdick needs to reply. So
Yes.
how long do you expect to be?
so
before
I'm
you-
slightly behind where I thought I would
Yeah.
be. I think I'm going to need at least until 1 o'clock. I'll try to conclude, but Mr. Wilcox will be very short. He told me no more than 15 minutes. No, because
Right.
he's only dealing with a very narrow point
Yes.
of ground too.
Yeah.
I will very much
Be sorry to miss him. Right.
I would be sorry if you did.
But I appreciate we've asked quite a lot of questions recently, but still.
No, I will move. I will move as fast as I can, my lord. So the point I want to make on that. So when we get to in Rossendale the application of Ramsay to the circumstances of that case, that's dealt with in paragraphs 48 to 50. It's the focus is on who's the party with the real and practical ability to make the property available for occupation, but the Supreme Court emphasise at paragraph 51 that the defendant's motive in granting the lease was to avoid paying business rates, but that's not the basis of their decision. So paragraph 51, the motive itself is not a material part of the basis of the decision. If the lease is entered into by the defendants had the effect they were not liable for business rates, their motive for granting the lease is irrelevant. Well, that's an important sentence, I respectfully submit.
Can we just look at that though with 49? I think there may have been some discussion of this in Emerald Shaw.
Yes.
They put a twin. They set it as a twin requirement in 49. Company which has no real or practical ability to exercise its legal right to possession, and on which that legal right has been conferred for no purpose other than the avoidance of liability for rates.
So one needs both.
Yes.
Yes, and
So to that extent, because you could describe that second part as a motive, to that extent they are they're not focusing on whether the grant of the lease as such was for tax. We'll deal with that later, but they are imposing a twin requirement. So they clearly think it's consider it relevant, if not critical, that there should be no purpose other than the avoidance of liability to rates.
I do take issue with the concept of purpose, but my lady is. But if
purpose, unfortunately, in tax, it may be different to rating.
Right.
Purpose does have a subjective connotation. It is very different from what you do. So we've got a problem with language here. But let's
Yes.
try to put that to one side. My point is that the aim, or whatever you call it, of avoiding liability for rates was considered a relevant part or critical part of the
but not a sufficient one. As my
No,
lady-
clearly not
yes.
sufficient, but a part of it.
It's a part of the context in which the Ramsay principle came into play.
Yes.
And there, we do need to look at this through the subsequent case law, because it obviously was picked up on. But if I can signal it this way, where I get to is my submission is, for the purpose of the issues in this case, one does need to think carefully about in rating the established use of motive and purpose. But if what my lady is putting to me is that there were two elements and both were important, and one of them is rates mitigation as the sort of contextual operation of the potential for this line of active interpretation to be in play, but it's not sufficient. The second limb is that this has an effect that we if I go back to the and on which the legal right has been conferred for no purpose other than the avoidance. So the legal right was effectively, in that case, it was an entitlement without any consequential action in relation to the hereditament. It's a different limb of the regulation. So may I come back to that, because I don't dissent from what you're putting to me that there are two elements. I do submit that in the rates context, motive of tax avoidance is an easier way to think about this, but it may be that we're assisted by the divisional court's decision in Robinson Webster in understanding that. So may I come back? Yeah, and in paragraph 51, as I said, they are expressly disavowing motive. So that there's
That's in, sorry,
So, yeah, as I read it as a layman in these matters, the second sentence says, if the scheme works, the motive is irrelevant.
yes.
But the word if is carrying quite a burden there.
Yeah, well, and it didn't work in Rossendale. There's completely different dynamics. My submission is I accept the burden on that if, but the scheme works because of the meaning of the words used and the statutory requirements in this case, and I therefore do endorse my Lord's formulation. If so, in my case, if there is rateable occupation, then the statutory conditions are met in accordance with the statutory machinery properly construed, and this is on all, this analysis is on all fours with that. So the motive itself, so it's all pointing in the same direction. The motive itself is nothing to the point. There isn't a general, or it isn't sufficient in itself, and there isn't a general. You must construe it to re-legislate it if it's tax avoidance. The point is, can we do that, having regard to the effects of the actions which are in fact taken? That is the if in my Lord's formulation, and I say that if plays out very differently on our facts to how it does in Rossendale. May I just make two further points before I leave Rossendale? So paragraph 56 of Rossendale, they go back to Barclays Mercantile, and I draw attention in particular, and obviously Arrowtown, and then I draw attention to paragraph 57. We think it's important to note that the conclusions reached in McNiven and Barclays Mercantile itself, that the statutory provisions relied on in those cases were intended to apply to particular transactions undertaken solely for the purpose of avoiding tax relief, were in each case the result of a close analysis of the legislation and the relevant facts following a Ramsay approach, and not a determination that the Ramsay approach did not apply. And that's important because the statutory interpretation, once you understand it and once you look at what the statutory conditions are, they can lead to a conclusion that the effects of what is done are such to meet the relevant conditions of entitlement, properly construed and having regard to the statute as a whole and its purpose. And that's not an abdication of Ramsay, that's an implementation of Ramsay, and that's the Barclays Mercantile insight. So that's an important point, I respectfully say. The critical question is the effect of what's done such as to answer the statutory description properly understood in the context of the scheme as a whole and its purposes? And then the second point I just want to make is in relation to uncertainty. So obviously paragraph 61 is the much cited conclusion that uncertainty isn't a reason in the way of the outcome in this case. And I accept for the purpose of my submissions the point that made that that's a general proposition. It's not linked to it being an unusual case. That's what this court decided in Emerald Shore. So that's the bit that's often cited. But can I go back to paragraph 60, because uncertainty, this observation about uncertainty, it was prayed in aid by counsel for the defendant companies in that case, and he said it would be too uncertain for denoting someone other than the person with immediate right to possession of the property, and it would be inconsistent with the intention reasonably be attributed to Parliament that ratepayers and rating authorities alike should be able to determine without difficulty who's liable. And then the Supreme Court observed this: there is force in this argument if the test is formulated, as it was by appellants in their written case, as one of a genuine and real commercial entitlement as owner. That is an amorphous formulation, but a recognition that Section 65 vests a real and practical ability to occupy or put someone else in occupation is a purposive interpretation which achieves some coherence. So the point I make is this idea that you can have here, you can differentiate between genuine and real commercial entitlement. That's described as an amorphous concept, and the Supreme Court's not interested in giving effect to an amorphous concept. Now, I say that if we are inventing an approach to beneficial occupation that is tailored around tax avoidance rather than applying the general law, and doing that because of Ramsay, one is stepping into an amorphous concept where you're having regard only to certain types of occupation because they are perceived to be non-commercial. That does not admit to drawing defensible boundaries. It is the definition of an amorphous boundary, and the paper cup example is an illustration of that, but also the shape of my learned friend's argument, if I could just give you a reference on that slips out, I respectfully say, in his skeleton argument, because he, in paragraph 68, he talks about the need for a, quote, commercial use. Well, that's exactly the same formulation as what's depreciated in Rossendale. So then may I go to Falk and Merchandile? Yes. Which is tab 19, and I'll deal with this as shortly as I can. The facts are horrendously complicated, and I'll try and duck out and just deal with them in outline, if I may. But the claim is for a writing down allowance. The claim for a writing down allowance fell within the statutory purpose of Section 24(1) of the Capital Allowance Act of 1990, irrespective of the question of whether the other transactions have any commercial purpose, is the conclusion of the Court of Appeal upheld in the Supreme Court. If I use the head note just to orientate us in the facts, the case concerns the financing of a pipeline. So the Irish statutory gas supplier completed a pipeline for the transport of natural gas from Scotland to the Republic of Ireland. An investment bank, part of a major UK banking company, proposed a scheme whereby the pipeline, which was not expected to earn any taxable profits in a sufficiently short time to absorb capital allowance if taken directly, be made the subject of a sale and lease back with a UK company able to utilise the allowances in its own group and pass on the benefit to BGE. The scheme envisaged the purchase by the UK company of the pipeline, the grant of a lease to the UK subsidiary, the guarantee by another company, the main bank in the banking group, of the rental payments under the lease, a long-term supply contract between this subsidiary and BGE, and a cash deposit of a sum a little below the expected purchase price. After discussion with other potential lessors, a finance agreement similar to the proposed scheme was made between the taxpayer company, which was part of the banking group. The claim for the writing down allowance under Section 24 in respect of the purchase price of 91 million was refused by the revenue. So the finance lease was part of a wider structure of arrangements. The revenue refused it. The appeal was dismissed before the Special Commissioner. The High Court upheld the Revenue's position. The Court of Appeal, the judgment of Lord Justice Carnworth, as he then was, overturned it, and the House of Lords upheld the decision of the Court of Appeal. If I could just take the holding first and then go to the critical part of Lord Nichols' judgment. So, dismissing the appeal, the taxing statute was to be applied by reference to the ordinary principles of statutory construction by giving the provision of purposive construction to identify its requirements and then deciding whether the actual transaction answered the statutory description. That before any question arose as to whether elements of a transaction were to be disregarded as having no commercial purpose, the requirements of the particular provision had to be identified. Section 24(1) of the 1990 Act required that a trader should have incurred capital expenditure on the provision of machinery or plant for the purposes of his trade, which in the case of a financing lease meant the acquisition of machinery or plant for the purpose of leasing it in the course of trade. That such statutory requirements were, in the case of a finance lease, concerned entirely with the acts and purposes of the lessor without reference to what the lessee did with the purchase price, and that accordingly, since the purchase price and leaseback of the pipeline was part of the company's ordinary trade of finance leasing, the company having acquired ownership of the pipeline that would generate income for it in the course of its trade in the form of a rent chargeable to corporation tax in return for payment, and since none of the transactions involving the other companies were necessary elements of creating the entitlement, the company's claim fell within section 24, irrespective of any question of whether other transactions had any commercial purpose. So in short, they're drilling down to what the statutory requirements are, and they're identifying that they are satisfied by an element of that, and that being so, the overall avoidance or overall transactions didn't detract from that overall conclusion. If I could pick up the relevant reasoning and deal with it as briefly as I can, it starts at paragraph 26 on page 246, and this is under the heading the Ramsay principle. They observe that the attempts to clarify that have only led to fresh doubts, that there's a desire to take the opportunity to give definitive guidance. That's paragraph 26. They then cite various elements of the case law, and at paragraph 32 they draw the threads together. The essence of the new approach was to give statutory provisions a purposive construction in order to determine the nature of the transaction to which they were intended to apply, and to decide whether the actual transactions, which might involve considering the overall effect of a number of elements intended to operate together, answered the statutory description. And that then they cite paragraph 36. They cite various case law, including Furness, and at 36 they draw it together. Cases such as this give rise to a view that in the application of any taxing statute, transactions or elements of transactions which had no commercial purpose were to be disregarded, but that is going too far. It elides the two steps which are necessary in the application of any statutory provision. First, to decide on a purpose of construction exactly what transaction will answer the statutory description, and secondly, to decide whether the transaction in question does so. And then there's reference to the ultimate question, which we're familiar with from Rossendale. Paragraph 37, the need to avoid sweeping generalisations about disregarding transactions undertaken for the purpose of tax avoidance was shown in McNeven. And then there's reference to the comments of Lord Hoffman in McNeven, which sought to draw a distinction between a transaction that was commercial and one that had a legal effect, and Lord Nichols observes, if I pick it up at letter F, that is not an unreasonable generalisation, indeed perhaps something of a truism, but we do not think that it was intended to provide a substitute for a close analysis of what the statute means. and then at 39 and 40 they put some flesh on the bones of that general proposition in terms of the focus on what the statute actually requires, by looking at the object and giving effect to the interpretation, and the conclusion is that the transaction answers the statutory requirements, and that's expressed in paragraphs 39 to 42 in relation to the circumstances of that case. So the upshot of that, I say, is that very much anchors the concept of Ramsay as an exercise in statutory interpretation, and it's looking at the focus of what the statutory machinery actually requires and whether the relevant transaction satisfies that. So translating that to our present purposes, if there is a lease, as here, and an overt act of occupation pursuant to the entitlement to occupy under the lease, which meets the requirements for rateable occupation for 6 weeks, then that is what matters under the statutory scheme, because that is, to use the language of Berkeley Mercantile, answering the statutory description. And that is a really important limitation on what Ramsay can do, which is reinforced in Rossendale, that paragraph 57. If you go through that exercise and you reach the conclusion that the effect of what's happening answers the statutory description, then that's the beginning and the end of it. Obviously, what that statutory description is needs to be informed by purposive analysis and the scheme as a whole. Here, purposive analysis put property back into use. Scheme as a whole, single use of the concept of occupation on both sides of the occupied non-occupied divide. It's the conscious deployment of a well understood term as the relevant measure of whether that period is there. So that takes us back, I say, to the relevant inquiry: are we meeting those statutory conditions? If we are satisfying rateable occupation as understood in the traditional law, which I submit we are, then there's no Ramsay additionality to add to that. We meet the conditions of entitlement. May I then move on very quickly to Emerald Shore, which, if I hope I don't do an injustice to, but my respectful submission is this confirms that Rossendale is not, if you like, in some extra exceptionality category. It was an appeal from a refusal of judicial review to challenge the findings of a district judge that that there was, applying Rossendale, there was no practical entitlement to intention. The facts were it's another unoccupied property case. There was a tenancy at will granted to a charity, Space to Help. They were relying on a provision we've not looked at, but it's under unoccupied rates. If it's next in use by a charity, then you can secure an exemption, and that was held not to be effective because the charity didn't have the practical ability to make the property available. And as is encapsulated in paragraph 77 of the judgment, part of the context was that there was a redevelopment scheme going on at the property, and my Lord Justice Holgate, with giving the judgment of the court, describes at paragraph 77 the air of unreality about the appellant's case in that case. So that's the context, and the ratio is reinforced in this case that in paragraph 43 that there is no extra requirement of exceptionality or unusualness. See paragraphs 43 and 44. So my submission is Emerald Shore reiterates Rossendale. It's an application of Rossendale to a situation where you had property that was empty. There was a debate about who had practical control, the facts of that were fairly unattractive because there was a scheme of redevelopment going on, and in that context it's a straightforward application of Rossendale for property which was everybody was contending was empty. So I don't propose to say more about that because I don't understand it to move forward the jurisprudence beyond confirming there's no separate test of exceptionality.
Could I ask you about paragraph 80 of Emerald Shaw?
Yes.
Is that a correct understanding of the effect of Rossendale? How you apply it? I think you referred yesterday to the language used there, significant and integral part of the test laid down in Rossendale, and I think that may be a mistake and cross-referring to paragraph 43. I think it may be another paragraph, but leave that to one side.
I think this goes back to the discussion I was having with my Lady Justice Falk a few moments ago, and I, as expressed there, it's part of the relevant equation. I would pray in aid to be balanced against that proposition read on its own, paragraph 51, which is the disownment of motive per se.
Yeah.
So I think that's an important qualification. But if what you're putting to me, if I may put it this way, is that it's a necessary but not sufficient part of the context in which Rossendale operates, I do accept that. But there are two qualifications on that. Firstly, that motive per se is not to the point, and the second one is that if the effect of what is done is such as to answer the statutory description, then it wouldn't, in those circumstances, be a significant and integral part of the test. It would be part of the test, but not a significant and integral part of it in those circumstances.
Deciding what is the statute description is a process of interpretation.
Of the words used in the statute.
Purposively.
Yes,
Yeah.
but my submission here is that there's much less wriggle room in this case than there is in Rossendale.
Because of the breadth of occupation.
Because it's occupation according to the general law, effectively.
Yeah.
And that's the key sort of functional difference. So we can answer the effects in this case in a way that they didn't in Rossendale, and the Supreme Court had a much more open texture opportunity. So Mills, I noticed the time. May I haven't finished. I'm sorry. May I have up to 15? I hope up to 15. But a small amount of time.
Yeah.
After shorter journeys.
That sounds reasonable.
Thank you very much.
All rise if able.